Good morning, everybody. Thank you for joining me for today's webinar. We're going to be talking about how AshBer can help you and your clients with Medicaid crisis planning. If you're interested in a copy of the handouts from today's webinar, feel free to download those out of the GoToWebinar dashboard, or if you have any questions about today's webinar, feel free to type those into the questions section of the GoToWebinar dashboard as well. My name is Amber Hines. My maiden name is Amber Gwynn. Some of you may know me as Amber Gwynn, but I have spent the last 15 years working with elder law and estate planning attorneys across the country on Medicaid compliant annuities. I am insurance licensed in all states and hold a Series 65 license with FINRA. And I created AshBer to assist advisors as well as attorneys with pre-planning solutions and crisis Medicaid planning solutions. Some of the different insurance solutions that we provide include Medicaid compliant annuities as short as 2 months, prepaid funeral policies, and hybrid long-term care insurance policies. When we're talking about crisis planning, the first two items are going to be considered viable spend down tools to use in a Medicaid crisis plan, whereas the third option, the hybrid long-term care insurance policies, are going to be more of a pre-planning solution because the client still needs to be insurable or healthy enough to qualify for a hybrid policy. So when we look at the Medicaid compliant annuities that we offer, we can do annuities as short as a 2-month time frame, and as long as the client's Medicaid life expectancy, which would be determined either by the Social Security Administration table or a state-specific life expectancy table if your state has one. We do only work with A-rated insurance carriers when we are placing Medicaid compliant annuities. Whereas if we're looking at a prepaid funeral policy, this is going to be a viable Medicaid spend down tool, and it is advantageous to use in a situation where clients don't necessarily know what funeral home they want to use for a funeral, because the policies that we would offer are completely portable, so they can be used at any funeral home across the country, and it's going to be a life insurance policy that is irrevocably assigned to be able to pay for funeral expenses. The last solution that we offer is hybrid long-term care insurance policies, or some people refer to these as asset-based long-term care insurance policies. And this is really combining a life insurance or annuity policy with a long-term care rider so that there is a residual death benefit that would be passed on to an intended heir if the insured does not end up needing to use the long-term care benefits from the policy. So this is going to be different than your traditional long-term care insurance policies, which are similar to your auto or home insurance, that there is no cash value that can be passed on to your intended heirs if the insured doesn't actually need to use that policy. Like I said, today our main focus is going to be on crisis planning, specifically Medicaid planning. So me talking about the hybrid long-term care insurance policies is not something that is going to be covered in today's webinar. When we look at the different services that we provide, we are able to assist with complementary planning assistance, including support funding a Medicaid compliant annuity, which I'm going to talk more about. And then we also provide review of existing annuity contracts that your clients may have purchased and you're not sure whether they are going to be problematic for Medicaid planning purposes or if they are already Medicaid compliant. And then finally, we assist with the death claim process for any annuity that would be purchased through our agency. When it comes to complementary planning assistance, we really work with your office, however works best for you. So we have some law firms and some advisors that we work with that simply request simple quotes from us. So they do all of the calculations at their office and they contact us to receive a simple quote, whereas we have other offices that will request a complimentary Medicaid analysis from our office, which I'll talk more about as well. So first, we're going to talk about the planning and funding assistance that we're able to help with. To start out, how to contact us, the best way to contact us is either by email, phone, or going to our website and filling out a quote request on our website at ashber.com. If our office is provided with your client's gender, their age, marital status, income, the type and amount of assets that they have, we're able to assist in developing a complementary Medicaid plan. So this would include assisting with figuring out how much needs to actually be spent down for Medicaid qualification purposes, and then also the best way to plan for your clients as far as the term of the annuity that could be chosen to get the best result for your clients. The services that we provide for Medicaid crisis cases, if we are looking at an individual case, so no spouse being involved in an individual case, we would be providing assistance with calculating the gift and the annuity amount. And so some people refer to this type of planning as a half a loaf or reverse half a loaf plan, where we are taking the excess resources that a client has over the $2,000 asset limitation in most states, and we would be calculating how much the person is able to gift and how much would need to be put into a short-term Medicaid compliant annuity to cover a penalty period or a private pay period. If we have a community spouse case, meaning one spouse is in a nursing home or applying for Medicaid and the other spouse is remaining in the community, then we would be providing assistance with a spousal annuity calculation. So this is going to include calculating how much the community spouse is able to retain as their community spouse resource allowance, and then looking at the different types of assets that they have to determine how long the annuity should be structured for the community spouse. And then finally, if we have a married couple case where both spouses are in a nursing home or both spouses are applying for Medicaid, then we would provide assistance with calculating the gift amount as well as the Medicaid compliant annuity amounts for each spouse. Our last webinar in February was based on both spouses being in a facility and needing to apply for Medicaid. If you're interested in looking at those calculations, you can find a copy of the webinar from February on our website at ashber.com. The different factors that we look at to develop a case are going to include obvious things like whether we're dealing with an individual client or a married couple. Also, we're going to consider the client's ages and their anticipated longevity. So planning for somebody that is in their late 60s is going to be different than planning for somebody that is in their early 90s. We also would be taking into consideration whether the couple or an individual has made previous gifts within the last 5 years that are going to be considered penalized transfers or trigger a private pay period for Medicaid qualification purposes. And then finally, we're also going to look at the type of assets that your client owns, as well as the amount of assets that they own. So if we're looking at clients that have all of their money in a checking or a savings account, that is going to be different than a client that has a lot of money invested in pre-tax accounts like IRAs, retirement accounts, and then also taking into consideration the amount of assets that need to be spent down. A $500,000 annuity is going to be different than a client that wants to place $10,000 into an annuity. So all of these different factors that you're seeing on the screen are going to be things that we take into consideration when we are developing a complementary Medicaid plan for a client. The different types of assets that can be used to purchase a Medicaid compliant annuity, it really is going to be any liquid asset that a client owns can be used to purchase a Medicaid compliant annuity. So if we have clients that have checking, savings, certificates of deposits, stocks, bonds, brokerage accounts, whole life insurance, non-qualified annuities, or IRAs or retirement accounts, any of these types of accounts can be used to purchase an annuity. If they do have stocks, bonds, or brokerage accounts, any of these types of accounts will need to be liquidated to a cash position before we can actually purchase the Medicaid compliant annuity. But if you have clients that have whole life insurance policies, non-qualified annuities, or IRAs, those are going to be assets that we can consider doing direct transfers of in order to purchase a Medicaid compliant annuity and do that in a tax efficient way. So before instructing a client to liquidate accounts, it's important to review the client's financial information to determine what the best way is to plan for the assets that they have. So if you have clients that own existing whole life insurance policies or non-qualified annuities, we can potentially use these types of accounts to initiate a tax-free 1035 exchange. And if you have clients that have retirement accounts, we can potentially initiate a transfer or a rollover of these types of accounts, which we're going to be talking more about all of these items next. So whole life insurance and non-qualified annuities. Whole life insurance does have cash value that is going to be considered an asset for Medicaid qualification, as well as non-qualified annuities are going to be considered an asset as well. So if we're looking at different ways that we can plan for these types of accounts, they are going to be considered assets. And so we can either surrender a contract and have the client receive a lump sum of cash. Otherwise, we can exchange these types of accounts and exchange them for a Medicaid compliant annuity in order to do that in a tax efficient way. The first option with surrendering a deferred annuity, like I said, because the deferred annuity is a lump sum of cash, the annuity owner can contact the insurance company who issued the annuity and surrender the annuity contract. Upon surrendering the contract, the owner is going to receive a cash settlement amount, and the settlement amount is really going to depend on how long ago the annuity was purchased and whether there's a surrender charge or an early termination fee. So depending on when the annuity was purchased, surrender charges or early termination fees can range anywhere from 15% down to 0%. An annuity that was just purchased within the last year or so is going to have a much larger surrender charge than an annuity that was purchased 10 years ago or 5 years ago even. So as the annuity is held on to for a longer period of time, that surrender charge is going to decrease over time. Instead of surrendering a deferred annuity or a whole life insurance policy, we can consider exchanging an existing contract for a Medicaid compliant annuity. If you have clients that have a deferred annuity or a whole life insurance policy that has significant growth, or it was purchased several years ago, we can consider a 1035 tax-free exchange in order to exchange the existing annuity or life insurance policy for a Medicaid compliant contract. A 1035 exchange is going to be a provision in the tax code that allows a policyholder to transfer funds from an existing annuity or life insurance policy into a new annuity. 1035 exchanges must occur between products that are like kind. So if you have clients with a life insurance policy, it can be exchanged for another life insurance policy, or a non-qualified annuity can be exchanged for another non-qualified annuity. And finally, a whole life insurance policy can be exchanged for a non-qualified annuity or for a Medicaid compliant annuity, which would be, in this case, considered the non-qualified annuity. When we look at the taxability of non-qualified annuities, if we look at our example on the screen where a client invests $150,000 into a non-qualified annuity and it has now grown to $200,000, the first $100,000 that was used to purchase the non-qualified annuity is not going to be considered taxable. That's the principal or the initial basis that was invested into the contract. But the $50,000 of gain or interest is going to be considered taxable if the client were to simply surrender or liquidate that annuity contract. Another option, instead of simply surrendering or liquidating the existing annuity and having to incur the tax consequences on the $50,000, would be to do a 1035 exchange into a Medicaid compliant annuity so that the $50,000 would be equally taxed over multiple tax years. And so if we look at the example on the screen, if we were to do a 1035 exchange of the full $200,000 into a 24-month Medicaid compliant annuity that's generating around $8,400 of monthly income, then the full 200,000, or excuse me, the full 50,000 is not going to be considered taxable right off in 1 year. So it's going to be taxed over multiple years as the $8,400 makes payments over a monthly time frame. That is going to be a portion of that 8,400 is going to be considered taxable as the payments are made. So this illustration here is showing you the difference in surrendering the contract or liquidating the contract and the client having to pay $50,000 of taxable income in 1 year versus if we do a 1035 exchange and the annuity is generating around $8,400 of monthly income. Most of the principal that you're seeing in blue is not going to be considered taxable, but a portion of each of the annuity payments would be considered taxable as the annuity is making payments. In this example, if we structured the annuity over a 24-month time frame and the annuity started making payments in, let's just say, April of 2021, then a portion is going to be considered taxable in 2021, 2022, and 2023. So you're really spreading out the tax consequences over 3 different tax years by doing the 1035 exchange. If you have clients that have existing retirement or pre-tax accounts, we can use those types of accounts to initiate a transfer or a rollover. Not all state Medicaid agencies are going to consider retirement accounts to be countable for Medicaid qualification purposes, but if you do live in a state that retirement accounts are countable, then clients are going to have 2 different options in order to spend down an existing retirement account. They can either surrender the retirement account and pay all of the taxes up front, or they can utilize an IRA Medicaid compliant annuity. The map that you're seeing on the screen here is showing you all of the states that consider the Medicaid applicant or the institutionalized spouse's retirement account to be countable versus exempt. All of the states that you're seeing in white are going to consider the Medicaid applicant's IRA to be a countable asset, whereas the states that are in orange are going to be states that consider the institutionalized spouses or the Medicaid applicant's retirement account to be completely exempt or exempt if the individual is receiving systematic payments from the contract or their required minimum distribution. This chart here is showing you, or the map here is showing you the states that consider the community spouses retirement accounts to be either countable or exempt. And again, the states that are in white consider the retirement accounts to be countable, whereas the states that are in orange are going to consider the community spouses retirement account to be completely exempt or exempt if the person is receiving their systematic payments or required minimum distribution for IRS purposes. Clients that have retirement accounts that have to be spent down for Medicaid qualification purposes because they live in a state that considers the retirement account to be countable have two different options to fund a IRA Medicaid compliant annuity. We can either use a trustee to trustee transfer or a 60-day IRA rollover to fund the IRA Medicaid compliant annuity. The different types of accounts, retirement accounts that can be transferred or rolled over into an IRA MCA. It is not just an IRA to IRA that can be used to fund an IRA Medicaid compliant annuity. If you have clients that have existing 403Bs, 401Ks, or other retirement accounts, we can transfer or roll over these types of accounts as well. You're seeing on the right-hand side a chart from the IRS's website that is outlining the different types of retirement accounts that can be rolled over from, like a SEP IRA plan, a 403B, any type of qualified plan into a traditional IRA Medicaid compliant annuity. You're seeing that in the second row of that chart. How it works, the transfer versus a 60-day rollover. A transfer is going to occur by the IRA MCA annuity company obtaining the money directly from the current custodian. And so if you have a client that has an existing retirement account with Raymond James or Wells Fargo, we can send transfer paperwork that would allow for the annuity company that is going to fund the Medicaid compliant annuity to obtain the money directly from Raymond James or Wells Fargo. Whereas a 60-day rollover is going to require that a client is going to request the funds directly from Raymond James or Wells Fargo. They're not going to have taxes withheld from that distribution, and then they're going to reinvest the funds into a Medicaid compliant annuity within a 60-day time frame. The advantage of doing a trustee to trustee transfer is that we can do an unlimited number of transfers within a 12-month period, whereas with a 60-day rollover, we're going to be limited to one rollover per 12-month period. So if the client has multiple IRA accounts or pre-tax accounts that they want to use to fund the IRA Medicaid compliant annuity, we would have to proceed with a transfer because we can only do one rollover per 12-month period. With a transfer, all of the tax reporting is going to be completed between the two companies, because the client is never actually going to take possession of the funds with the transfer. Is going to all occur between two different financial custodians. Whereas with the 60-day rollover, the tax reporting would need to be completed by the client. So the client is going to indicate when they get their taxes done the next year that they did receive a distribution from their retirement account and that that money was reinvested within a 60-day time frame. The only downside really of the transfer, the trustee to trustee transfer, is that this can take anywhere from a couple of weeks to over a month to complete, which in most cases is going to delay Medicaid eligibility until those transfers are completed. We're pretty much at the mercy of the current financial custodian to release the money quickly to the IRA Medicaid compliant annuity insurance company, whereas the 60-day rollover process is going to be quicker because that is going to be dictated by the client contacting the current custodian and requesting those funds so that it can be reinvested within a 60-day time frame. So there's a bunch of different variables that would be taken into consideration when determining whether we would do a trustee to trustee transfer or a 60-day rollover. The biggest indicator is going to be if there are several retirement accounts that need to be transferred into the IRA Medicaid compliant annuity, then we're kind of stuck using the transfer versus the rollover option. The next type of service that we're able to assist with is reviewing existing annuity contracts that clients own. If you have clients that have existing annuity contracts, we're able to review those policies and provide the clients with options of how to best plan for those types of annuities that have already been purchased. Annuities can be confusing, but they're also one of the most popular investment vehicles, especially for clients that are in retirement age. So many of your clients likely already own annuities, so it's important to understand that there's different types of annuities and how we can best plan with those types of contracts. There are two different types of annuity contracts. First, a deferred annuity, and second, an immediate annuity. A deferred annuity, like we have talked about, is going to be considered an asset for Medicaid qualification purposes. Principal or the initial lump sum that is invested into the deferred annuity can be withdrawn or annuitized at a later date, and a deferred annuity can be surrendered and is revocable. All of those properties or characteristics mean that Medicaid is going to view a deferred annuity as accountable asset because the contract does have a cash surrender value that the client is able to access. Alternatively, an immediate annuity is going to be strictly an income stream, so it is no longer a lump sum of assets. So it is an annuity contract that has been annuitized within a year of purchasing the contract, which means that it pays out principal and income over a period certain or a certain number of years or over the person's life expectancy or for the rest of their life. Generally, the election to annuitize an annuity is irrevocable and cannot be undone. So changing the annuity from an immediate contract to a deferred annuity is not an option. An immediate annuity cannot be surrendered and it is irrevocable as to the income stream. So once we do make the election to annuitize a contract or invest in an immediate annuity contract, it is no longer a lump sum of cash and is strictly a payment stream that the client would have access to either based on a number of years or for the rest of their life. not all immediate annuities are going to be considered Medicaid compliant. Many people think that if an annuity is in payment mode, or if the election to annuitize is an irrevocable election, that automatically means that the immediate annuity is Medicaid compliant, but that is not the case. In order to determine how Medicaid is going to view an immediate annuity, whether it's going to be considered income to the client, an asset, or possibly a transfer for less than fair market value, or an uncompensated transfer, we look at a number of different factors to determine how Medicaid will treat the annuity purchase. These different factors are going to include whether the annuity was, when the annuity was purchased, whether it was purchased before the Deficit Reduction Act of 2005 or post DRA. We also would be looking at whether the annuity was purchased with post-tax dollars or non-qualified funds, or if it was purchased with IRA money. There's going to be different rules for annuities purchased with post-tax dollars versus IRA funds. And then finally, we're going to look at whether the annuity is assignable, or whether it can be sold on the secondary market to companies like J.G. Wentworth or Peachtree, companies that would purchase structured settlements or immediate annuities on the secondary market. And finally, another service that we are able to provide is the assistance with the death claim process when an annuity would be purchased through our office. As most of you know, in most cases, when a Medicaid compliant annuity is purchased, in order for the contract to be Medicaid compliant, the state Medicaid agency is likely going to be the primary death beneficiary, to the extent that they would provide Medicaid benefits on behalf of the Medicaid applicant or the institutionalized individual. There are a few different exceptions to the state Medicaid agency being listed as the primary beneficiary. This is going to include if there is a minor or disabled child. These individuals can be listed before the state Medicaid agency. And then also in married couple cases, some states allow for the institutionalized spouse to be listed as a primary beneficiary before the state. Since most annuity owners do end up outliving the term of the annuity, the primary beneficiary being triggered in most cases is not all that likely. But if it does happen, then we're looking at a situation where we need to determine who is listed as the beneficiary and what the options would be upon the annuity owner passing away. So if the state Medicaid agency is listed as the primary beneficiary, we would reach out to the state Medicaid agency in order to determine whether Medicaid benefits were provided to that client or to their spouse. Depending on the state, it usually takes anywhere from 2 to 6 weeks in order for us to obtain this documentation. And once we receive that documentation, the insurance company is able to then pay out anything that would be remaining to the secondary or contingent beneficiary. But if the state Medicaid agency does have a claim, they're likely going to receive the amount that they are owed in a lump sum cumulative value. Whereas if a spouse, minor, or disabled child would be listed as the beneficiary, these parties are going to also have the option to either continue the monthly payments on the annuity or receive a lump sum cumulative value. The state would also have that option to continue to receive the payments or to receive a lump sum cumulative value, but most state Medicaid agencies are going to elect for the lump sum cumulative value versus waiting to receive the payments. The beneficiaries of a Medicaid compliant annuity are going to have the option to either continue the payments as scheduled or receive a lump sum commuted value. If we look at an example of a client that purchases a Medicaid compliant annuity structured over a 60-month time frame and is scheduled to make 60 payments of $1,750 over the time frame of the 60-month term, the total payout you're seeing is $105,000, which is a little bit of interest that would be paid in comparison to the single premium of $100,000. If we assume that the annuitant passes away 30 months into the Medicaid compliant annuity term, there would be 30 months remaining in the term of the annuity contract. The beneficiaries could either continue the payments as scheduled. So if the beneficiaries continue to receive the $1,750 over a 30-month time frame, the total payout that they will receive over the 30 months is going to be $52,500. Whereas if the beneficiaries elect for a lump sum commuted value, instead of the beneficiaries having to wait 30 months to receive the $1,750 each month, they would be able to receive a discounted amount or a commuted value around $49,000 that would be paid to them up front versus having to wait to receive all of the payments over the 30-month time frame. The pros of continuing the payments as scheduled are going to include that the beneficiary receives the full value from the annuity, so there's not going to be a discount rate that is assessed, whereas the disadvantage or the con of the beneficiary continuing the payments would be that they have to wait the 30 months to receive all of the funds back. Whereas if the beneficiary elects for the lump sum commuted value, they're going to receive the $49,000. So it's going to be a slight discount rate from the full amount that they would have received if they waited 30 months, but they're going to receive all of that up front. So there's no need to wait for the remaining 30 months of the annuity contract. The disadvantage or the con of the lump sum commuted value is obviously that they are not receiving the full value from the annuity by electing that lump sum commuted value. A summary of the different types of services and solutions that we're able to provide. We're able to provide assistance with Medicaid crisis solutions and planning services. Like I said, we only use A-rated insurance carriers for Medicaid compliant annuities. We're able to issue contracts as short as 2 months. And we're really here to assist with the entire process of the Medicaid annuity purchase, from funding to the planning assistance. And if your client does end up predeceasing the term of the annuity, we're also able to assist with the claim process as well. And at this time, I will see if anybody has any questions for me. I'm not seeing any questions at this point, but I want to thank everybody for joining me for today's webinar. Next month's webinar, we're going to have a guest presenter, Todd Watley, who is a certified elder law attorney. He's going to be talking about the basics of Medicaid, as well as how he has built his practice specifically geared towards elder law. Feel free to register for that webinar on our website, ashber.com. And if you think of any questions for me after today's webinar, feel free to reach out either by phone or email. Again, thank you for joining me, and I hope all of you are doing well. Take care.